Time once again for another edition of Chicago's Legal Latte. Hi, everyone. I'm Jim Mitchell, and as always, a pleasure to take some time to talk to some of the folks from Lavelle Law. And joining me today are the managing partner, Ted McGinn, and associate Joshua Brill, who's joining us for the first time on our podcast. So, Ted and Josh, first of all, thank you for being here. Great to see you guys today.
Always good to be here, Jim.
Thanks, Jim. Looking forward to it.
We're going to talk today about a very interesting topic, one that's been around for a long time. We've talked about it in previous podcasts. I know your folks have written articles on it. That's non-compete agreements and how they factor into certain businesses and, quite frankly, the legality of them, how they stand. And there's been some changes recently in how they are viewed. So we want to kind of get into that. But I guess, first of all, it's a term we probably are mostly familiar with, but what specifically is intended by having a non-compete agreement?
Yeah, so first of all, where do these come from? Well, they came out of a desire for businesses to protect certain confidential information or to protect trade secrets. If they hire a worker to come in, they disclose that worker this private confidential trade secret that they're going to use in the operation of the business. And the concern is, obviously, they leave and go somewhere else, they have that private information that they can use competitively against the employer. So that's where these restricted covenants came about.
Were they generally enforceable? I mean, would companies be able to do this?
Yeah, they were generally enforceable as long as certain few components were met. First of all, there had to be a legitimate business interest, which typically means there's got to be, a trade secret or some sort of non-public information. And then number two, the covenant must be reasonable in geographic scope and duration. So that typically means that the covenant can't be for extended period of time. Usually a couple of years is usually what you're looking at. And then the geographic scope, it has to be some sort of, 30-mile radius or, certain counties, maybe in some situations, certain states, but it should be some sort of reasonableness tied into that geographic scope. So that was the old rules as far as enforceability of these covenants.
And just to be clear on that legitimate business interest, does that mean that a company can't say, I'm going to corner the market on a good talent, I'm just going to make them sign this so they can't ever go work for a competitor, regardless of trade secrets or anything else? I just want the best salespeople. I want the best engineers, whatever it might be.
Yeah, historically, there has to be more than just simply wanting them to sign the agreement. There would have to be confidential information, non-public information, or a trade secret that the business is seeking to protect. Now, another area where you would commonly see these things is in the context of a sale of a business, because in that situation,
Okay.
the buyer, they want to make sure that the business effectively transfers over, and the only way for them to ensure themselves of that would be prohibiting the sellers from engaging in competition right after the sale. Because otherwise, if that wasn't there, the seller could simply open up a shop right across the street, and all the customers and employees walk over, and the buyer doesn't really get any benefit of the purchase.
When you mentioned some of those restrictions, limitations, geographic and otherwise, duration, are those sort of covered globally, or are these managed state by state, or what's the jurisdiction on managing these?
Well, again, it needs to be somehow tied into the business that we're dealing with. I mean, if a business simply operates in just a town of Schaumburg, for example, it'd be very difficult for that business to have a covenant that would extend outside of Illinois or even outside of the Chicagoland area. So it has to be some sort of reasonableness tied into the covenant. And so that's something that, of course, historically would look at. Why the covenant is drawn in this way.
And when you mentioned the courts, go ahead, John.
Just to add on that, what Ted was saying there, Jim, and what we'd have to do a lot with that too is the types of non-compete it is. So if it's a employment situation, it'd be related a lot to maybe where the business is actually located, where the employee is located. But if it's a sale of business, that territory could go farther, because when you're selling your business, it may reach to those other areas, maybe some other states or other territories where that business is doing business. So I think it's just good to note that between the two different ones, it could be a little more expensive in the sale of business.
And what we want to kind of get into today a little bit is talk about what's happening in the state of Illinois with these covenants and some federal action. So does every state have their own rules? Because you mentioned going to the courts sometimes, Ted. Is this sort of unique from state to state how they are enforced and enacted?
Yeah, I mean, at this point, it is, well, leading up to more recent, what the FTC is trying to get to, and we'll get to that in a little bit in this podcast. But before then, it was a state by state matter. Each state had their own rulings, own body of law that would be applicable within that state. But again, that may be changing. I mean, the FTC, which is a federal organization, is coming out with some rulings recently that we'll get to. But historically, it was a state by state matter.
Okay, and let's talk about the FTC, because that's sort of what prompted our discussion today with some a recent action by the Federal Trade Commission relative to these covenants.
Jim, there's a couple things that I want to bring up. One thing too that we've kind of forgot to go over is you have two different types of restrictive covenants. You have the non-compete, and that's a covenant that prohibits a party from engaging in any sort of competition. And then you have kind of a lesser strict covenant, which is known as a non-solicitation. A non-solicitation is a form of restrictive covenant. That covenant allows the party to go out there and open up a competing operation, but you can't solicit either the employees of the business or the customers of the business. So there's different types of covenants, and statutes deal with them a little bit differently depending on the nature of the covenant.
Okay, so are they likely to be intertwined? Would a non-solicitation be part of a non-compete, or are they really two separate actions?
Yeah, sometimes they may be within the same document, I suppose. Maybe the drafter of a document, maybe they want to make sure that they have some protection, so they put both. If a court strikes down a restrictive covenant being too broad, they at least left with a non-solicitation, so that's better than nothing. So I think sometimes you see both of those covenants. I don't know. What do you think, Josh?
Yeah, I think you see both of them together. Like Ted said, I don't think they're necessarily need to be tied together, but when you put one into an agreement, it kind of makes sense to put the other one in. If you're not going to let them compete, you probably don't want them soliciting your customers, your employees, things like that. So while not directly related, you do see them together a lot.
Okay. Well, again, we're talking with Ted McGinn, Josh Brill from Lavelle Law, talking about non-compete agreements. And now let's move over to what, again, has prompted our discussion today, some recent actions by the Federal Trade Commission, the FTC. Josh,
I'm going to stop you again, Jim. You're going too fast. Okay, so before the FTC action, there were some actions that the state of Illinois took leading up to it. I mean, these covenants are beginning, for a period of time, getting more and more difficult to enforce. So in 2013, in Illinois, there was the Fifield decision that came out, and that's the appellate court held that for these covenants to be enforceable, there must be adequate consideration. That was a new requirement that was tossed in the mix. And what adequate consideration was deemed to be either 2 years or more of continued employment, or there must be some sort of separate payment, some sort of monetary payment made in order for those covenants to be enforceable. Before the Fifield decision, in the employer-employee situation, just simple an employment relationship was enough to support it. But after the Fifield decision, the courts held that was not enough. They need 2 years of continued employment or some other monetary compensation.
And so just clarify that. So what that said, that an employee must have met those requirements before they could be required, or before it could be enforced? Before
an employer can enforce the covenant, they must have adequate consideration. And that means either the employee must have been employed for 2 years consecutively with the employer, or the employer must have paid that employee some additional consideration, more than just the compensation that they're getting paid for performing as an employee.
Okay. And that you referred to as happening in 2013. Any subsequent actions in Illinois then?
Yeah. Thereafter, the state actually codified Fifield a little bit and kind of expanded it a little bit. So basically, the codification, they have a couple more restrictions. First of all, covenants not to compete would be prohibited in an employer-employee situation if the employee earns less than 75 grand per year for salary. And then for non-solicitation, they were not enforceable where the employee earns $45,000 or less a year. So those are additional codification that they kind of laid out compensation thresholds that must be met for those things to be enforceable.
All right, can I jump to the FTC now, or we got?
Now you can jump to the FTC.
All right, Josh is waiting to share with us what's going on there. So go ahead, Jack.
Sure. So, Illinois kind of took the lead amongst other states and kind of, bearing down on these restrictive covenants and finding out which ones were necessary, which ones were not, which ones were fair. And there had been talk of a long time of the FTC taking action federally to either restrict or somehow, make sure these are fair, these non-competes. On April 23rd, 2024, the FTC released their rule, and it banned all non-competes. So just to be clear, we're talking about only non-competes here, not non-solicits,
Okay.
not confidential information, not other types of restrictive covenants. This is just non-competes. And basically they said any non-competes moving forward would be banned, and any non-competes previously signed and in effect would be banned unless the person was a senior executive with the company. And a senior executive means that they're making over $151,000 per year and have a policy-making role. That's kind of a ambiguous term a little bit, like a CEO, president, officer of a company. And also excluded from this FTC ruling are those sales of business we had talked about. So in those transactions where someone's selling a business, you can still have that non-compete clause because, frankly, without it, as Ted mentioned earlier, what's to prevent the seller from opening up a shop next door and taking all the customers? So that's excluded, as well as the senior executives already included. Both were not included.
Okay. So that happened in April. So we're talking, 4 or 5 months ago. Challenges to that since then?
Absolutely. So that ruling came out on April 23rd, 2024. On that very day, like I said, this was in the works for a while and people were ready. On that very day, a case was filed in the Northern District of Texas. It was Ryan LLC. It was an accounting firm versus the FTC, basically arguing that the FTC does not have the authority to issue this rule, and that their actions were arbitrary and capricious. They didn't go through a process looking to see if there were other methods of controlling non-competes. And the court agreed with them on the merits. So they issued a temporary injunction, meaning that the rule couldn't go into effect as of yet until they made their final decision. So that was the first case. Very next day, another case was brought. This was in Pennsylvania, ATS Tree Service LLC versus the FTC, and pretty much argued the exact same case, that the FTC overstepped their bounds, didn't have the authority, arbitrary decision. Yet the Pennsylvania court found exactly opposite of the Texas court. They found that the plaintiff didn't have really the merits to succeed. So you have two courts disagreeing with each other, but the Texas ruling was the one that we'll talk a little further about because there was some more recent action with that one.
And is that district court?
Yes.
Okay.
So in Texas, it was the Northern District, and in Pennsylvania, it was the Eastern District.
Okay. So we're getting down to our last couple of minutes here, but this is where we want to get to. So go ahead, Josh, kind of take us through now what's happening with that Texas case.
Yeah, absolutely. So like I said, it was originally just a temporary injunction issued by the Texas court, waiting to see how they would rule in the future on it. And they came out with their ruling on August 20th, so about a month ago, and they found that the FTC did not have the authority to issue this ruling. They completely set aside the non-compete ban, and that's kind of where the status of this is right now. The FTC, as of yet, has not appealed this decision, although it's very expected that they will. Maybe they'll try to change some of the way the rule is worded or something to fit that court's findings. But as of right now, they haven't appealed. August 20th, it stayed, it's set aside. It was supposed to take effect actually September 4th. Obviously, that's about 3 weeks ago at this point. So now we'll just wait and see what the appeal process brings. And even though the Pennsylvania court, and there was actually another court that ruled the other way, that Texas court decision is holding right now, and that rule is set aside.
So let's do this before I have you guys give contact information where people can follow up with you. What does it mean for businesses in Illinois right now?
Well, what it means for businesses in Illinois right now is just that the Fifield ruling and the Illinois statute is still in effect. This rule, it's kind of like it doesn't exist at the moment because it's been set aside, but it's certainly waiting in the wings. We draft employment agreements, stuff like that. We still include non-compete language because it's still in effect. But at any moment there could be appeals and stuff like that, and we'll see where this goes. It'll be a really fast evolving topic.
Okay. For people who do want to talk to you, businesses or otherwise want to get some more information, what's the best way to reach out and get in touch with one of you guys?
Our main number is 847-705-7555, of course, and our website is lavellelaw.com. You can find all of our contact information as well as our other practice groups that we work in. So yeah, that's the best way to get out in touch with us.
Fantastic. All right, Ted, Josh, I know there's a lot more we could talk about. Maybe we'll do a follow-up. Keep us posted on what's happening, and we can see what the next turn of this event would be. But for now, thank you for taking the time and kind of sharing some information with us today.
Thanks for having us.
Absolutely. Thanks, Jim. Thank you.
Thanks, guys.